America's founders are calling. It's your opportunity to respond. This is the Liberty Brief Podcast with your host, Robert Melso, featuring Dr. Thomas Giordano. Welcome to episode 5 of the Liberty Brief Podcast. I'm your host, Robert Melso, and today we'll continue our conversation with Dr. Thomas Giordano, author of the book Unalienable: What It Really Means and Why It Matters. In the last episode, we discussed the 4 types of liberties upon which our form of government was designed. The intent was to produce a fair institution to govern the free society our founding generation envisioned. In effect, the drafters of our Declaration of Independence and our Constitution reprioritized those classes of rights to center sovereignty on the individual. What a concept. This was, in fact, a revolutionary and positive alternative to the kinship and feudal hierarchy common to their day. We also talked about there being 2 separate realities which define us all, one real and natural and the other fictional and legal. These 2 conflicting states under government give rise to contradictions, the confusion, and the perplexities in our civil lives. In this episode, we're going to talk about the many activities which we would commonly call crime. We will also examine its central role in the creation of societies and government. So, with that, welcome, Dr. Tom.
Oh, hello, Rob. How are you today?
I'm doing great. Thanks for asking. Dr. Tom, our last episode was full of information about our rights, their origins, and how they were prioritized in the United States. But the topic today is crime. Now, I think we all have a pretty good idea of what crime is and how it is handled in our society with the court system. It's pretty much common knowledge, I guess, that if you break the law, you could be arrested, indicted, brought to trial, perhaps convicted, jailed, fined, whatever. But I was thinking about the state of nature. I have a couple of questions about that. And firstly, what are crimes in the natural environment? And secondly, who is expected to enforce justice or redress of a grievance in the state of nature? Maybe we should first try to define just what a crime is. What is a crime?
Well, in the simplest way to define a crime that would cover almost all of its variations is any act done in violation of the duties which an individual owes to his species, to his community, or to his society. Technically, in society, a crime is any act committed or omitted in violation of a public law which either forbids or commands it. In other words, it is the law that defines the crime. In nature, though, this is quite a different story.
Okay, that's what I think I was getting at. How is that different in nature?
Well, in nature, there are no crimes. Crimes can only be committed if there is a written code which reflects the moral considerations of a society or the laws imposed by a government. Since natural law is not a written code, any breach or violation of a duty due to another's natural rights, whether they are believed to be God-given or simply a species-specific inheritance of our humanity, are more properly termed a desecration or a sacrilege, even a blasphemy, rather than a crime. In nature and in civil society, all violations can be boiled down simply to theft.
Really? Just theft?
Yes, yeah. Think about it. Theft, by definition, implies other ownership. Under natural law, everyone is endowed with self-ownership. Therefore, everyone owns their life, their body, their dignity, their reputation, their free will, their intellect, their labor, their personal liberty to move around, and all the fruits of their actions, money, property, wealth, and so forth. If they are deprived of these possessions against their will or with the threat of violence, their ownership has been violated.
You want to tell that to my tax accountant?
Yeah, well,
I think I understand that, but why a desecration or sacrilege?
Well, because this is how we define actions which damage or treat something holy or deeply venerated without any reverence or respect. We have many cultural examples of this from Greek and Roman and Old Testament sources that predate written history.
Okay, I guess I'll bite. Can you give us some of those examples?
Sure, sure. Now, if you recall the previous podcasts, um, the ancient Greeks and Romans considered their properties as sacred enclosures. They viewed property ownership not only as a holy concession of their gods, but as the representation of the lives of the and labors of themselves and their ancestors. Therefore, any trespass or theft of the fruits of their labors was considered a sacrilege. In other words, by encroaching upon their rights, one was infringing upon the will of the gods and disrespecting their authority. The idea is the very cornerstone of democracy. So, another example would be when Heracles mistakenly murdered his family, and he was not executed. He was exiled and directed by the oracle at Delphi to atone by following the commands of his twin brother. He was given 10 seemingly impossible labors to perform. 2 of them were discounted because he received assistance from someone else. So they ended up being 12. Let me see. And another illustration would be in the book of Genesis when Cain slew his brother Abel. Of the many lessons we may learn from that story, we may also notice that God neither prevented the act nor did he smite Cain. He did not even pronounce a sentence of death upon him for fratricide. Now, you have to remember, Abel's murder took place way before the 10 Commandments were handed down to Moses on Mount Sinai. The Jewish judicial doctrine of an eye for an eye, a tooth for a tooth, was not yet codified into law. In all of these examples, the sacrileges were violations of the natural order and therefore against nature's God and required atonement. This was the reason that both Cain and Heracles were exiled and not struck down.
If you look at it that way, I would guess practically all Greco-Roman mythologic stories are lessons in cause and effect.
Oh, exactly. The ancient Greeks did not have the benefit of the Holy Bible to give them an outline of a moral code of conduct to apply to society. Their understanding of morality came from the archetypal stories of mythology from the Age of Heroes or from Homer's Iliad and Odyssey while they were learning how to read and write.
Then, Dr. Tom, how was justice imposed? I mean, I guess who was responsible for providing justice or redress for violations of natural law?
Well, I would say that depends upon what you mean by justice. Justice can be seen as punitive or restorative. Now, you must also consider the point of view of the parties involved. An effect to any action may be immediate or delayed. For example, if I try to murder you, your defense of your life is an immediate response which could end my life on the spot. If I succeed in killing you, and your family, clan, or tribe seek me out and kill me, this would be a delayed response. These would be forms of punitive justice and are imposed either by the intended victim directly or by those who suffer directly from the victim's loss. Now, remember, we're talking about being in a state of nature and not in a civil society. In society, eliminating the murderer is of benefit to everyone in the community because his potential threat to kill another has been eliminated with him.
So I think you're saying that you could take revenge. Justice could be seen on different levels. Personal is the first, and I guess familial is the second, and communal or societal would be the third. And is revenge the correct word?
Well, I would say justice.
Justice.
Let's say justice, okay, at this point. Because we'll have to explain this a little bit later. But yes, you asked me who was responsible for providing justice or redress for violations of natural law. As nature is understood to be a self-balancing system, nature itself will provide the process, but it is the perpetrator of the offense that ultimately will provide justice or redress.
Wait a minute. Dr. Tom, how is that? I mean, how can we really expect the offender to punish himself?
Well, Rob, you're thinking in terms of social notions of justice, not natural ones. Okay. During the Bronze Age, the ancient Greeks were closer to an understanding of natural law. Back then, the usual answer to serious offenses, including murder, was banishment or exile. Sometimes it was permanent, sometimes it was long term. You would be ostracized from your native land until you atoned for your actions. The Greek term for this is exiliono. Interestingly, you would not lose your property, your wealth, nor your citizenship. You would still have access to any income produced from your land. It was their way of getting rid of the source of contamination to restore a balance of nature. As a matter of fact, the Native American people had similar views when dealing with heinous offenses within their tribes.
You know, that reminds me, the last time I forgot um, our marriage, the date of our marriage, my wife put me into exilieno.
Exiliono, excuse me.
Exiliono.
Exiliono.
Yeah, I was
Yeah.
exiliono. Where does the revenge come into the picture? I mean, I would think that revenge for being wronged would be a prime mover.
Well, there is a great difference between revenge and vengeance. Okay.
All right. So I think we need to get those defined. Aren't they both attempts to make the offender suffer as he made the victim suffer? You know, the eye for an eye kind of thing.
Well, I think you'll be surprised by the intent of of that particular doctrine in Jewish law. You know, it wasn't just Jewish. That doctrine actually came from the Code of Hammurabi, which was way predates the Torah. You are right. Vengeance and revenge are seeking the same ends, but their motivations are different. When a punishment is driven by malice, which is not needed for the purposes of justice, it is called revenge. This also is a very atrocious crime. A punishment is vengeance when it is driven solely by a simple love of justice. The need for punishing offenders to support the rule of law is warrantable and just. In this, it is a just retribution, recompense, or punishment.
All right. So revenge, bad, and vengeance, acceptable,
Yes,
right?
yes, yes.
I think I understand what you're saying, but I'd like to return to the notion of an eye for an eye. I've been led to believe that this was pretty much foundational in our Western idea of justice.
Yeah, well, it is. It is. It is fun. It is foundational. But you know, the wisdom of societal Jewish jurisprudence teaches us that the punishment should be commensurate with the crime and not out of spite. But you must ask yourself why they believe this. It was precisely because they knew the difference between revenge and vengeance. You see, if they took the punishment to the extreme and overstepped the relationship to the crime, then they themselves would be guilty of committing an atrocity against God and nature, for which they would eventually have to atone. They were aware that the laws they followed in civil society were based upon natural laws. When either set of the laws was violated, there were two realities they had to adhere to, one natural and one man-made. Their punishment could not be an affront to God. This is the reason why Jesus' approach was so revolutionary to his time.
I think I'm beginning to see why this is the better approach, although I have to say revenge just seems much more fun.
Yeah. Revenge seems to be the natural response, right?
But revenge means that you could overstep the boundary of natural law in your action and therefore create a repeating cycle. Now the person that wronged you is now the wronged individual, and they would be entitled to revenge, or I guess you're saying vengeance.
Vengeance, exactly.
And
because
if they overstepped their bounds, it would be an eternally repeating cycle, sort
right.
of like the Clampetts and
the Hatfields and the McCoys,
yeah.
or the Greeks and the Persians, if you wish. Yes,
right.
Yes. What would happen is that the person passing judgment, let's say in a court of law, would then have committed. He would be guilty of having committed an atrocity against God, an affront to God, and then he would have to atone. When we're talking about Jesus, however, his only concern was restorative or reconciliatory justice. Excuse me, one of returning balance to the natural order which the Creator had set in motion. His statement of turning the other cheek took man made law out of the equation. It eliminated the possibility of revenge while leaving vengeance to the balance of nature.
Okay, maybe you can explain that to us a little bit more because it may not be so obvious to some of us.
All right, well, okay. Well, listen, Rob, in the natural order, all life forms are driven to survive, including us. One of the characteristics of the survival drive is to always find a justification, no matter how unreasonable, for our own transgressions, Okay? We either do this or tend to deny what we did in our own minds. However, nature will never forget the existence of the transgression. Let's take Jesus' example. Let's say some guy comes up to you and, for whatever reasons he may have, slaps you across the face. Okay? The overt act of the transgression also becomes a motivator for you to either mete out justice with the guy who slapped you or to transgress against someone else whom you consider warrants such an act. Right? It starts and perpetuates a destructive cycle of cause and effect that will spread throughout the entire community. If you do not respond in kind, you are not providing him with immediate justice, punitive justice. He will be forced by nature of by let's say the natural balance of nature to find justice elsewhere.
Okay, I think if I understand what you're saying, by suggesting that I turn the other cheek rather than slapping back, the offender has to look elsewhere for a delayed justice. Would you say that this would be restorative?
Oh, I would suggest that it's both punitive and restorative. You see, he has to throw himself into a self-imposed exile. Deluding himself that he got away with it once, he may continue to do it again. Eventually, he'll slap the wrong person who'll give him all the justice he'll ever need. A couple of weeks in a hospital bed may very well be the just recompense to restore order to his universe. You see, Jesus' message here was that natural law takes no notice of man-made law and will function just fine on its own, as long as you subtract yourself from the cycle and don't turn that transgression into a motivation to transgress against someone else. So if civil law is in accordance with natural law, everything will retain its balance and harmony. Vengeance will be satisfied. Revenge won't enter into the picture. There are also some really positive spiritual lessons to be learned here, but we won't go there right now.
You know, it just seems like if you're dealing with a bully, they respond very well to positive feedback, if you know what I'm saying.
You mean negative reinforcement.
If you don't stop them in their tracks at the very beginning, they go on to bully someone else, and there's repercussions to that I might not like.
Yeah, well, the thing is that bully will eventually find somebody who's not going to take being bullied around. He will eventually meet someone stronger, someone bigger, and he'll put him in his place. The only thing is that the people who are bullied, they have to break that cycle and not take it out on someone else. It's like, let's say you go to work and your boss yells and screams at you, and then you go home and take it out on your wife. Well, that perpetuates a cycle of violence, basically. So that's what we were trying to get away from. You see, it was restorative justice that Christ was looking for, not punitive.
Okay. Well, I think you've spelled out an underlying understanding of the way natural law and natural justice works. I have to be honest, I never gave it that much thought, which is why I asked those two questions. But given what you've just explained, I can see that when a crime is committed in society against a written law that's been based in natural law, there are actually two violations going on, a crime and a sacrilege, in your words.
Yes, it would seem that way. Yes.
You also said that there was a difference between vengeance and revenge, which I think I understand now. This is another subject that I never thought about. But I can also see now why so many people are gut-wrenched at a meager sentence, which grates against their internal sense of justice. And I
Yes.
happen to know someone that just was the victim of a crime, and the perpetrator got parole without any other punishment
Right.
from the court, and
Right.
they were devastated.
Yes, of course, because their internal sense of justice was ignored. If you remember the film The Godfather, the opening scene of The Godfather is precisely that. Bonacera comes in and says, my daughter went out with these two American guys and they tried to violate her and they beat her like an animal and all that. And they walked out and they laughed at him in the court. So he goes to Don Corleone for justice. And when he asks him to overstep his bounds and kill these two, what does Don Corleone say to him? That's not justice. Your daughter is still alive.
Yeah.
Then he says, all right, well, then make them suffer as they made her suffer. And he agrees, without going into, but the thing is that is an eye for an eye and a tooth for a tooth. Don Corleone, in meting out the justice, was saying, I can't over, extend the justice in spite. I have to make them pay an equivalent amount. You see, so that's vengeance. That's not revenge.
Right. Well, the horse didn't think that, but.
Well, the horse, that's
okay.
Khartoum.
Let's change lanes a little bit and talk about laws once a society forms. Now, I understand that the English-speaking countries, for the most part, are known as common law countries. But first, I'd like to establish the link between crime and the need to group into societies and their need to eventually create governments. You made the statement at the beginning of this podcast that all crime is theft. You implied this is the case in the state of nature as well as in society. Am I right?
Yes, that's correct. Excuse me. That's correct. If you think about it, what would be the primary concern of people living in an uncivilized environment? I would say protection against theft. Raids by outsiders, which could take your life. They could abduct family members. They could rob the fruits of your labor or destroy your property, basically run roughshod over your life. Now, we here in America are centered on the individual, but the family unit is the actual basis of societal structure. So unifying with other families to form a band, then unifying bands to form a clan, then clans to form a tribe, and so on, increases your family's chances for a peaceful existence. It makes perfect sense that cultural agreements to assure and safeguard your property would be derived from the only law that you know, which is the unwritten natural law. As your societies expand over a wider area, and tribes unite to form nations, the differing local customs and traditions need to be uniform in application across the field. So statutes based in interpretation of morality are then written into legal codes.
So you're saying that this is where common law comes from?
Yes. Most of the United States inherited a functioning ancient system of common law from the British. And it remained with us, after the break from the crown. This system of laws gets its strength and authority from the general consent and long established practices of the people, and is based on precedent instead of statutes passed by a government. Since the law is created by judges when deciding, individual disputes or cases, we call it case law.
All right. Can you tell us something about how this system developed?
Yes, well, as far as I understand, the English had two categories of courts: law and equity. In the law court, the judge applied statutory law. These were laws that were written by legislators. Over time, however, unique cases arose that were not covered by statutes. And as a way to correct these legislative oversights, judges themselves created law, usually in equity. This is what we refer to as common law.
So, what you're saying is that both natural law and common law have no underlying written code associated with them. The cases, the cases themselves determine, let's say, the illicit act. And since we're talking about precedents in law, I take it that these cases in common law are eventually recorded and archived into a code.
Yes, that's right. As I said before, common law has no statutory basis enacted by a legislator, and judges establish common law through their written opinions, which give direction to subsequent decisions of the lower courts in the same jurisdiction. Customarily, let's say, common law generally covers areas related to property, contracts, and simple torts or civil wrongs. You see, its proceedings review the type of theft. We call it harm or damages, which are then adjudicated in reference to socially accepted moral values of the people where the case in question has occurred.
All right. So I think I see where this is going. Once there's a legislative body in government to then come around to pass laws, they would then be codified as separate from natural and common law.
Yes, yes. Civil and criminal statutory law. This is codified. This is, a codified set of legal statutes created by legislatures at either the state or federal level. The U.S. Code, for example, is a federal collection of statutes and rules. Here, the system clearly outlines which claims can apply to the court. It also outlines how these claims are to be processed and what the prescribed penalties or punishments are for the offense. Now, these codes are repeatedly restructured because, every time a legislature meets, they're writing some kind of some kind of a code. But the aim is to standardize codes to assure order and eliminate unfair applications of justice from one case to another. Since the intent of a government in a free society is to guarantee equal application of the law to each of us, the goal of common law is the same as civil law. They both attempt to create consistent outcomes by applying the same values of interpretation.
Dr. Tom, I've always wondered about our jury system. I like the idea of being judged by a jury of my peers rather than by some guy in black robes looking down on me from a high bench, which, by the way, in my last traffic ticket didn't go too well for me. I'm curious about something, though. What if the law itself is unjust? What if the law was passed to appease some vested interest? How can we, as a people, get around a bad law?
Well, one way is through repeal by legislation. Another would be by ignoring it or not applying it. Actually, though they're never informed of it, the people making up the jury do have the power to determine if the law is unjust and throw the case out of court. Look, Rob, when there is a presentment before a grand jury to ask their permission to proceed to trial based upon the grounds or evidence presented by the Attorney General's office, the jury has the obligation to look at the evidence presented to determine if the law has actually been broken, if the actions of the defendant were justified, and if the law itself is just or constitutional. We are under no obligation to convict a person guilty of breaking an offensive or unjust law. The practice today leaves the people on the jury ignorant of their actual powers and has effectively turned these solemn procedures into a simple rubber stamp. Did you ever hear someone say the government can indict a ham sandwich if they wanted to? This is the reason. The same power is also found in the petit juries once the indictment comes down from the grand jury. It really is the unsung beauty of our judicial system. It's a shame it's being ignored.
You know, I'm thinking back to the time when I was on jury duty, and they never told us that we didn't have to apply based on their understanding of the law, and that if we felt the law was unjust, we could just simply ignore it. But I would say that someone is shortchanging us on our civics education. I was unaware of this.
Oh yeah, well, Rob, when was the last time you saw a civics class in high school? Please, don't get me started. Don't get me started.
Yeah, we called it something else. We called it, I forget what we called it, but it wasn't civics.
No, no, no. It wasn't civics. I remember,
It was something social studies. That's what it was.
yes, social studies.
Social studies. Well, Dr. Tom, I think we're both pretty angered with the undermining of our institutions and the degradation that we're seeing in our country today. In any case, returning to crime and punishment, you said something about ignoring a law. Now, how can a law be ignored? I mean, I ignored my traffic. Uh, I
Well,
ignored the speed limit, and that didn't turn out too well for me this
no,
one
no.
time. But
Well,
what are
that
we actually talking about?
well, we're talking about a law coming, let's say, coming down from the federal government. One way to one way would be to by annulment of the federal law by the state assembly. The authority is well explained by Madison and Jefferson's views in the Kentucky and Virginia resolutions of 1798. The state assemblies have a right to simply interpose and tell the federal government to take a hike. We're not enforcing this law. I mean, take the production, sale, possession, and use of marijuana in various states that have decriminalized it, for example. That's a perfect example of annulment, right? Also, believe it or not, there's an authority other than the state assembly and the jury that can overrule both state and federal laws if there is a popular consent regarding the law as either unjust or anti-constitutional, whether it be at the state or the federal level.
You know, is this where we get the idea of um, things like sanctuary cities?
Yes, of course. Yeah, that's there. There is a justification in declaring a city, let's say, free from federal law. That is a form of annulment.
You said something about ignoring a law, and you said that a law can be ignored by someone. Who would that be?
Well, let me ask you, who is the highest elected police official in your county?
My wife.
Yeah.
No, okay, the highest elected police official. That would be the county sheriff.
Yes. The actual role of the sheriff, aside from maintaining the peace, is to act as a barrier between the citizen's sovereignty in his county and tyrannical overreach by either the state or federal government. In time of crisis, he becomes the commander of the county militia. People often ask, well, who's going to lead the militia if it has to be formed? It is the county sheriff. Now, originally, the sheriff could write a letter informing the assembly and attorney general of his state, if it's a state law, or the Congress and the U.S. Attorney General or State Department that a specific law will not be enforced within his county, and any attempt to do so would result in the arrest of the agents sent into his jurisdiction to enforce it. Now, I did say originally, like so many other original intents, these powers have been diluted and absorbed in many states by placing the county sheriffs under executive gubernatorial oversight. Even state sovereignty has been effectively choked off at the federal level with the 17th Amendment.
And for the purposes of our audience, what does the 17th Amendment state?
Well, Congress passed a bill which gutted Article 1, Section 3 of the Constitution on May 13th, 1912. It was ratified on April 8th, 1913. The 17th Amendment allows voters to cast direct votes for U.S. senators. Before this, senators were selected by state legislatures. Okay. The intention behind selecting senators instead of electing them was to assure that the state's sovereignty wasn't usurped by the federal government. The senators selected could be recalled at any time by their state's assembly, and he could be replaced at any time. How much corruption in the Senate could have been nipped in the bud if the 17th hadn't been passed?
I'm trying to think of one senator that hasn't been corrupted by money, dark money, special interests, what have you, and are basically perhaps ignoring the will of the people that sent them there. But again, we come back to my ignorance of civics. I can't remember learning any of this in school. I was good at gym, however.
Yeah, well,
I mean, I did have social studies, but nothing really detailed about the country's founding documents. And I suspect a lot of our other public school students weren't taught these precepts as well. Those traditions specific to our adoption of British traditions and the like.
right, right. Well, you see, it was not the concern of senators. The will of the people was not their concern. You see, that the people closest to the people, the people in representative government and our government, closest to the people was the Congress. They are the ones that had to respond to the people. The senators were supposed to protect the state's sovereignty.
I really like the idea of calling them back when they screw up.
Absolutely. Absolutely. Well, Rob, let's pause and reflect upon what we have lost as a people since the founding. You're right about civics. Civics was once a requisite for high school graduation. The very purpose of public education was to produce thinking, well-informed citizens. This study was purged in the 1960s and replaced with that social studies class that you and I remember. Now, my father was disgusted by this deceptive transition. He seemed to know that there was an underlying agenda to subtly undermine our country by keeping our youth from knowing what was in the U.S. Constitution, the contract between the citizens and the government, the guarantees, the limitations on power, its fundamental principles, and so forth. Today, few know what's in it, and relatively few know what their rights are. Even fewer know why they should stand up and defend them. Hell, that self-declared so-called constitutional scholar Obama thought we had 57 states in the Union. He openly sneered at the Bill of Rights, calling them negative and as an impediment to progress.
Tom, to come to his defense, he was probably thinking of Heinz 57.
Yeah. Well, I don't know what he was thinking about, but I mean, this guy's supposed to be a scholar of the Constitution, doesn't know how many states we have.
Yeah.
No.
Well, he was a little confused. He also called Corpsman corpseman. I remember that speech.
Yeah. Yeah, they're still walking around. They're corpsemen.
It never ceases to amaze me how many politicians openly call our government a democracy. Now, I know that it's not, and I wouldn't even want to guess how many of them have never even read the Constitution they take to protect and defend, and then they go on to habitually ignore.
Right. Well, what can I tell you? I am hoping that they're using democracy as meaning a representative government and not a true democracy. But you can't you can't assume that. I mean, they certainly don't act as if they have read the Constitution. But let's look at a brief overview of our history. Okay, we declared independence from the British Crown with the intent of getting rid of a sovereign ruler over our societies and replacing him with individual sovereignty and self-determinism. We spelled out the reasons in the Declaration of Independence and formed the Articles of Confederation to unite the colonies in our effort for defense. These articles had no power to tax. It was intended to remain weak for a reason. Once the war ended, treaties were signed, debts were amortized, and our representatives came to terms with the inefficiencies of those articles. Now, if we go to the preamble of the U.S. Constitution, we read, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberties to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Okay?
Didn't they say for these United States of America?
No, it was but the states. United was a descriptor. It's the United States of America.
Okay.
It was written with a lower class U.
So you're saying that when they wrote "in order to form a more perfect union," they were saying more perfect than the Union under the Articles of Confederation.
Yeah, yes, exactly. I mean, it's not like they pulled the Constitution out of thin air. They had direct experience with an ineffective charter, yet having intimate knowledge of the failings and inefficiencies of that union, they still created our government without a standing army, with no police powers, no powers to tax, no ability to print money, and no ability to create a central bank. This is precisely what they considered to be their more perfect union. Now, can we honestly say that the mission statement here and in our Declaration of Independence is being observed today? Can we honestly say that we have the same federal government intended for us by Madison, Jefferson, and the rest? Is this what we are governed by today? Those United States organized themselves to protect the citizenry from theft at every level. The elected representatives of these United States spend most of their time drafting, passing, and enacting legislation, administering theft under the color of law.
Well, I would like to remedy that, but we are running short on time here. Let me just ask you this. Just when and why have these things in our country started to take a turn for the worse? I mean, when did we become unmoored from the Constitution?
Well, it was a slow process, but if you consider the Whiskey Rebellion of 1794, almost from the beginning, this was probably the first trial of the newly formed U.S. government's authority. You see, Rob, the colonists understood that there could be unjust written laws. They recognized that any statute passed with all of the earmarks of legality could still be completely devoid of justice. Our revolution was triggered following edicts coming out of London, such as the Townshend Acts, the Writs of Assistance, the Stamp Act, the Tea Act, and so on. Americans could immediately see that these acts ignored a respect for moral truths and natural rights. The corpus of natural laws was their standard for judging the rightness or justice of any enacted law, rule, or statute. They had enough, and they revolted. From there, I would say the Jacksonian era and then the Civil War started to alter our course. But if I had to pinpoint the start of the most dangerous trends, I would have to say it was near the end of the 19th century.
More proof that we probably need a convention of states at some point or another. But
yeah,
why would you
there's some
say
work
that?
to be done.
We can get
yes.
into convention of states in another podcast, but why would you say that, though?
Well, it became obvious because of there was a progressive infection of Marxist dogma into our society and government with the lies and false promises of progressivism. The idea of morality and ethics, which are so fundamental to our Western civilization, were intentionally attacked and undermined. The standards of natural law, virtue, and morality became the object of ridicule among self-proclaimed intellectuals, these sarcastic elites and self-serving lawmakers, being mocked and scorned by these progressives. Their conservative counterparts responded by avoiding any trace of moral reasoning and countering legislative and judicial attempts moving outside constitutional restraint. This is where inventing false constructions of supposed natural rights and non-enumerated governmental privileges arose, in frank violation of the spirit of our founding principles. From that point on, there was a gradual downhill slide with the 16th and 17th Amendments, the bastardization of the welfare clause, and so on to today. In any case, detailing this agenda is beyond the scope of this podcast. All I could say is that James Madison predicted it. He predicted it. He outlined it in his debate on the cod fishery bill before the House of Representatives in 1792. Our government is rapidly being transformed into an authoritarian oligarchy.
Dr. Tom, and as I've thought over this whole podcast and I'm listening to you, I'm beginning to think that the citizenry of the country are being mishandled in a way that violates their natural rights and, in fact, natural law. If that's the case, natural law should seek vengeance against those who would violate natural law. And I'm wondering where that vengeance comes from. And if, for instance, we get further and further away from this, does it get to a point where only violent upheaval corrects it? Or do we get to a point where perhaps it self-corrects? What's your thought on that?
Well, I have, look, the last time that it got way out of kilter was in the 1860s, and we had a civil war to bring it back into balance. Okay. I don't want to see that. And I think the American people today, I'm hoping that the American people today are more astute. But you have people that are actually pushing for this. And, violence is not the answer. Nature itself, if more sane minds basically take the reins, will balance this out by itself. The problem is that we have, unfortunately, we have Republicans on the opposite side of the Democrats who seem to be ineffective. I mean, things are starting to change now, but it took a figure like Donald Trump to start pushing back, and people that are following him, following that line, making America first again.
All right. Well, what I can't figure out is we're supposed to have political parties to balance each other out, to keep an eye on each other, precisely to counter each other. And for my part, I've noticed that the majority of every black spot that people want to bring up when criticizing this country, when you look at it, the one party is behind it. The slavery, the KKK, Jim Crow, poll taxes, segregation, the Dixiecrats. You can go down the list, Planned Parenthood, whatever, just to name a few. What happened to the Republicans? Where were they? I can understand what you just said about them adopting tactics to appease their counterparts in the political sphere, but whatever happened to their convictions? What happened to their principles?
Well, over the last 40 years or so, it has to be acknowledged that most Republicans are also the product of the same dogmatic American Marxist indoctrination in our schools as the rest of the citizenry. The only difference between the two parties today is that the Republicans intuitively know that what is happening is wrong, but they are not necessarily well grounded enough in constructionist principles. They only seem to come up with weak attempts to strip away the false data and inject the truth back into the political discourse. On the other hand, The Democrats are actively trying to fundamentally transform our country into what it was never intended to be. The Marxist progressive tactics, they appeal to the immature and childlike idealism of good feelings to purposely erode our institutions even further. The uber leftists employ the process of changing meanings of the words and not the words themselves, right from the old Marxist Bolshevik playbook. This is their go-to tactic in systematically seizing control and dominance over the people. To my mind, the Democrat Party is too rotted to the core to be saved. If the Republican Party doesn't regain their confidence in moral reasoning and right the course by returning to our founding principles and constructionist conservatism, America will go the way of all despotisms, and it won't be pretty.
Okay, well, we began this podcast talking about crime and its various forms and how they influence how we form societies and governments to act as bulwarks against it. I can't think of a greater crime than allowing our unique experiment, our American experiment, to be stolen from us without a fight. If our country collapses, what will come next should frighten everyone. And I want to thank you, Dr. Tom, for this great podcast. Our next topic will be episode 6, and those are the ideas of the Constitution. We'll be talking about what makes the U.S. Constitution so special, where the ideas came from. We'll talk about the various features of the Constitution that were supposed to keep us from becoming a theocracy or an oligarchy or what have you in the world today. So here we go. We're going to end this last podcast. Again, Dr. Tom, I want to thank you, and we will see you next time.
All right. Thank you, Rob. Thank you.
You've been listening to The Liberty Brief, based on the book Unalienable, What It Really Means and Why It Matters by Dr. Thomas Giordano. If you want to help spread the word, please subscribe, like, and share using the links below. You can also check out Dr. Giordano's book on Amazon using the links as well.